This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why a defendant who was incarcerated was still without an excuse for failing to respond to a complaint, and why, in almost every court in the land, failure to timely respond to a complaint requires the court to enter a default judgment. A default judgment, uncollectible because of the lack of UM or UIM coverage, leaves the injured parties with very limited ability to be indemnified for their losses. Timothy Ellis appealed the judgment of the Boone County Circuit Court. Ellis claimed that the trial court erred in not setting aside a default judgment entered against him. In Sharon, Cain, and Ronald Cain v. Timothy Ellis, the Court of Appeals of Missouri, on November 19, 2024, affirmed the order of the trial court. Sharon and Ronald Cain sued, asserting a claim of negligence against Ellis. The claim pertained to a motor vehicle accident that occurred in February of 2022. The Cains alleged that they suffered physical injuries, pain and suffering, and property damage as a result of Ellis's negligence. Ellis was served on September 21, 2022, while he was incarcerated in the Missouri Department of Corrections in Jefferson City. Ellis's answer was due on October 21, 2022, but he did not file an answer. The hearing on the interlocutory motion for order of default judgment was held on November 14, 2022, and neither Ellis nor counsel for Ellis appeared at the hearing. The trial court granted an interlocutory order of default judgment against Ellis by docket entry. The trial court later heard testimony from the Cains and from a doctor. The trial court received exhibits into evidence and entered an order of default judgment against Ellis in the amount of $1,500,000 to each of the Cains for a total of $3 million. Ellis filed a motion to set aside the default judgment while still incarcerated. The trial court denied the motion via a docket entry. Upon Ellis's request, the trial court entered judgment, denying the motion to set aside the default judgment. The Cains argued that Ellis failed to demonstrate good cause. The Court of Appeal concluded that Ellis's conclusory allegations that he was incarcerated did not satisfy the burden to show good cause. The Cains are elderly, aged 86 years old and 79 years old. They also stated that they would likely never recover money from Ellis, but were in the process of pursuing a tort victims' compensation fund award. They would not be eligible without a final money judgment against the tortfeasor. Finally, the Cains argued that Ellis lacked a meritorious defense. Ellis provided no explanation for how being incarcerated prevented him from retaining counsel or filing an answer in response to the Cains petition. Rather, Ellis essentially argued that being incarcerated was automatically good cause to be in default in court proceedings. Counsel for the Cains argued that Ellis was still incarcerated when he retained counsel and filed the motion to set aside the default judgment, which sort of put aside his argument. Ellis did not take any steps at all in the 30 days after he was served with the summons and petition. The first action from Ellis reflected in the record is his motion to set aside the default judgment while he was still incarcerated. The Court of Appeals found that the trial court did not abuse its discretion in finding that Ellis failed to show good cause for his failure to respond, and the Court of Appeals also noted that it was mindful of the argument that courts recognize the important policies favoring the resolution of lawsuits on the merits and disfavoring default judgments. However, there's a fundamental policy on which the administration of justice rests, that parties obey and respect orders of the court to appear or respond or otherwise take such action. In my opinion, if Ellis was insured, that insurer would have, if it was told the suit had been filed, a lawyer to respond to the suit. The appellate decision does not mention the existence of insurance, and since the plaintiffs wish to seek payment from the Tort Victims' Compensation Act, I can only assume Ellis was uninsured and that the Cains had no uninsured motorist coverage. This case teaches that people should buy UIM coverage at least equal to the limits available to third parties. This is a very frustrating case because both sides are victims. A $3 million judgment was entered, while Ellis was in jail, and the Cains can recover none of it since he is essentially judgment-proof. The Cains did not protect themselves with UIM coverage, and they are stuck with only having some tort victims' compensation fund provide them a little money. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. Please tell your friends and colleagues about this blog and these videos so that they too can subscribe. And if you subscribe, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and also access to the more than 4,900 blog posts. If you watch these videos on YouTube or rumble.com, I'd appreciate it if you were kind enough to click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.